Everyone. Welcome to the Environmental Law Institute's sixth session of our Summer School 2025 Basics of the Clean Water Act. We are so delighted to see you today. If you are not familiar with our Summer School series, it's a series that ELI holds annually, offering an introduction to the legal and policy foundations of environmental protection in the United States. We are now in the latter half of our Summer School programming for the year, but we still have a few sessions to go. We'll have one last in-person session at ELI's office in Washington, D.C. next week, which will also be live streamed via Zoom. This will be on environmental justice. After that, we will have two more webinar-only sessions on hazardous waste and sites, as well as disaster and mitigation law. The series is completely free and open to the public. All sessions will be recorded and uploaded to ELI's YouTube page and website for the public to watch later, so be sure to check out the recordings if you miss any sessions. And with that, I will hand things over to our wonderful moderator today. Adam Schemp is a senior attorney at ELI. His work focuses on water resource management, including water quality assessment, delisting for impaired waters, and restoration and protection planning, as well as water allocation strategies, water use efficiency, in-stream flows, and coastal use planning. Adam holds a JD from the University of Virginia School of Law and a BA in Ethics, Politics, and Economics from Yale University. I'll hand things over to you, Adam. Thank you all so much for being here today.
Thank you very much, Madison, and welcome everyone. This week's summer school course, as Madison mentioned, is focused on the Clean Water Act. We're going to begin with a broad overview, including the history of water quality regulation in the U.S., as well as a quick summary of the scope and structure of the Clean Water Act. We're then going to dive into the role of citizen suits, the importance of revolving funds and cooperative federalism, and the connection of environmental justice. We will conclude today's session with quick overviews of litigation and rulemaking concerning waters of the U.S., issues around agricultural runoff, challenges with PFAS and emerging contaminants, and the role of the states. So we are privileged to have two distinguished attorneys leading this tour of the Clean Water Act today. Robin Rotman is an associate professor at the University of Missouri. She also maintains a private practice of law through Van Ness Feldman LLP in Washington, D.C. Robin's research and teaching focus on the intersection of water, land use, and energy, with a particular interest on water quality regulation and nonpoint source water pollution. She holds a JD from Yale Law School, an MS in water science, policy, and management from the University of Oxford, where she was a Rhodes Scholar, and a BS in geology from Sewanee, the University of the South. Camille Panu is an associate clinical professor of law and the founder and director of the Environmental and Climate Justice Clinic at Columbia Law School, which uses comprehensive legal strategies to redress the disproportionate impacts of climate change on low-income communities of color. Before joining Columbia, she was a visiting co-director of UC Irvine School of Law's Community and Economic Development Clinic, and she founded and led the Aoki Water Justice Clinic at UC Davis Law School. Camille received both her undergraduate and law degrees from the University of California, Berkeley. So this session, as Madison mentioned, is going to conclude with a question and answer period. Hopefully we're going to have plenty of time for any questions that you all have. As Madison mentioned again, please use the question box and submit those at any time that those questions arise for you. I will be monitoring them over the course of this session. And if there's anything that is sort of a quick clarifying point, I will try to get that into the respective presenter as promptly as possible. Otherwise, things that might require a little bit more explanation, we'll hold those for the end. It's still very helpful to have all of those questions in as early as possible so that we can really jump quickly to the Q&A period once the presentations have concluded. So without any further ado, Robin, the floor is yours.
Thanks so much, Adam. It's a pleasure to be with you today and to be presenting with Professor Panu. As Adam said, we're going to take sort of a tag team approach. So I'm going to start out for 20-25 minutes with an overview of the Clean Water Act. So some historical bases, overview of the statute, and then a breakdown of its significant provisions. And then I'll hand it over to Dr. Panu, who will take over with citizen suits, revolving funds, and then a number of interesting case studies that have an environmental justice focus. And then we'll come back together for the third portion, giving a brief discussion of various current issues. As Adam said, we hope to have plenty of time for questions. I think we'll wrap it up by 1:15 Eastern, and then have about 45 minutes for questions. So again, it's great to be here. It's always a pleasure to collaborate with ELI on the summer school or other initiatives. I have to say my participation with ELI has been just a great asset to my professional development. There used to be an initiative called the Emerging Leaders Initiative, which was for early career professionals in environmental law. I think that program, that's one I participated in. I think that one has concluded, but there's always a way to become involved if you want to be a speaker or if you want to offer your expertise, either as a presentation or in writing. So again, Eli, thanks for the opportunity to be here. All right, so let's jump right in. Well, let's begin at the beginning, as they say, which is looking at the U.S. Constitution. And I've called out 3 provisions that are relevant to the Clean Water Act. The first is the concept of federalism and states' rights. So when the states, or when the colonies and states came together to form the United States, any power that was not expressly granted to the federal government was retained by the states. So if we're thinking about, which jurisdiction has authority over an issue, we need to look at the Constitution and see if there has been a grant of federal jurisdiction. Now, I'll tell you right now, read the Constitution, you're not going to see anything about water quality. You're not even going to see anything about environmental regulation. But what has become a basis for many of the federal environmental laws is the Commerce Clause that says Congress, so the federal government, shall have the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And as we'll discuss, this Commerce Clause has been the basis for regulation of ambient water quality, as well as many other environmental media. It's also responsible for other developments, such as ending segregation of segregated restaurants or lunch counters. What brought that down was that those facilities operate in interstate commerce, and so discriminatory state laws were a violation of the Commerce Clause. The last one I'd mention is the Supremacy Clause. So on issues where the federal government have jurisdiction, the federal law is the supreme law of the land. So states cannot issue a law or institute a policy that contravenes the federal law. And so we'll see this play out in the case of setting water quality standards under the Clean Water Act. So like I said, nowhere in the Constitution talks about water quality, but there are 3 early cases from the 1800s that really laid the foundation for what would then become the Clean Water Act. The first one back in 1824, Gibbons versus Ogden. This had to do with a steamship that would travel between New York and New Jersey and what the route and what the fare would be. This went to the Supreme Court, who said that because goods and services in interstate commerce are transported or performed by vessel, only Congress can regulate the water bodies where vessels may travel. So what that meant was the rates for this steamship would be set federally and not by either of the states involved. Then if we fast forward to 1865, there was a proposal to build a bridge over a river in Pennsylvania. But this would have impeded navigation, especially into the state of New Jersey. And so again, the Supreme Court ruled that Congress, and Congress alone, has power to keep navigable waters open and free from any obstruction to their navigation. This concept of an obstruction to navigation is one that we'll see in the early water quality legislation. So that the early legislation was not focused on human health or environmental quality, but really more on navigation and national security and defense purposes. And then the last piece I want to highlight here is one from 1871, a U.S. Supreme Court case dealing with the Grand River in Michigan. The state of Michigan was proposing some licensing requirements for vessels operating on this river. But the Supreme Court held that the state of Michigan could not do that because those were waters that were in interstate commerce. This is the first case then that goes a step further of, well, so we could say a water is an interstate commerce, but what does it really mean to be a navigable river? So this case defined it as rivers are regarded navigable in law if they are navigable in fact in their ordinary condition, using customary modes of travel on water. And over the course of the past 150 years, there's been litigation and rulemaking and executive orders and policy statements, really to try to define, we're still fighting today over this definition of navigable waters and what navigable in fact actually means. So, if you will, the first water quality law was the Rivers and Harbors Act of 1899. And this made it illegal to dump refuse into navigable waters without a permit from the U.S. Army Corps of Engineers. And like I said, this was focused on navigation and defense protection. It wasn't until 1948 that we saw the first law, the Federal Water Pollution Control Act, that began to incorporate human health. And this was primarily focused on sewage and human waste. This empowered the Surgeon General to investigate and seek to enjoin interstate water pollution. Now, this was before the EPA, but this was fairly limited because states had to consent to participate in this process. So if a state didn't want their wastewater plants investigated, there was nothing the Surgeon General could do. The next law that really is a strong precursor to the Clean Water Act was the Water Quality Act of 1965. It required states to identify intended uses, we'll talk more about that, intended uses of navigable waters within their borders, and to set corresponding water quality criteria, which is like either a numerical, like a pollutant concentration, or other descriptive characteristic of the water body. So this preview of coming attractions, this remained into the Clean Water Act and is still relevant today. The big thing about the Water Quality Act is this was more of a planning exercise. It didn't actually require states to enforce these standards or meet these criteria. And so there was, limited effect without that enforcement authority. Well, you might have heard that song, "The Summer of '69." I won't sing it, I promise. But what happened in '69? Throughout the 60s and into the 70s, there was growing popular awareness of environmental pollution and other risks from the way we were interacting with the environment. So here we have pictures of the Cuyahoga River in Ohio that caught fire. It actually caught fire a bunch, even before 1969. But that year also Lake Erie caught on fire. This from scum or oils on the surface that then become flammable. We also, looking now to the West Coast in Santa Barbara, California, had the Santa Barbara oil spill. And these events, if you will, really captured the public attention in a bipartisan manner. So over time, environmental regulation has perhaps become a more partisan issue. That's certainly true today with, say, the definition of a navigable water. But at this time in our history, there was a broad consensus that something had to be done to protect the environment and to protect human health. So on a bipartisan basis, Congress passed the Clean Water Act of 1972. So I included a screenshot here of the original text. You can't read it. So I'm going to highlight two of the key purposes. So the first was make all navigable waters safe for swimming and fishing. And then the next one is, it's hard to believe, but it was eliminate all pollution discharges to navigable waters by 1985. So these were very ambitious goals. They still have not been achieved today, but certainly the Clean Water Act has been invaluable at improving water quality and preventing degradation of water quality in the United States. Like a number of the federal environmental statutes, the Clean Water Act relies on a cooperative federalism model. So the key federal agencies involved are the Environmental Protection Agency and the Army Corps of Engineers, which I mentioned earlier. And so the statute gives the EPA and the Corps authority to implement the Clean Water Act. But this authority can be delegated to states or tribal governments. And this delegation of authority may be sought by states or by tribes, either for holistic implementation of the Clean Water Act or for only authority to administer certain functions. For example, to do water quality standard setting, but not permitting and enforcement. With states, we call this a delegated authority. For tribal governments, as I was putting these slides together, I realized this term is kind of showing its age because for tribal governments, what it's called is treatment as state status. Now, really, tribes are superior sovereign relative to states. But when it comes to Clean Water Act implementation, tribal governments basically can seek to be treated like any other state for implementation purposes. And where this cooperative federalism comes in, and the supremacy clause, is that state or tribal water quality criteria must be at least as stringent as the minimum criteria recommended by EPA. So the federal government sets a floor, and states can either adopt that floor, or they can have more stringent standards. So the key functions of the Clean Water Act. Well, it protects ambient water quality. So this is water quality in the environment, lakes, rivers, streams. The other big thing it does is provide grants and low interest loans, as well as technical assistance to municipal wastewater authorities. So I'm going to mostly talk about the protection of ambient water quality. Dr. Panu is going to talk about the grants and low interest loans. I do want to distinguish the Clean Water Act from the Safe Drinking Water Act. Because sometimes you think clean water, you think like, oh, it's the water I'm drinking. But no, so the Clean Water Act is about ambient water. The Safe Drinking Water Act is the federal law that regulates water from the tap. Specifically, it regulates public water systems. Those could be municipal systems, but not private wells or not bottled water, and some aspects of plumbing. So we're not going to talk about the Safe Drinking Water Act today. If you're interested, we recently released a podcast going into great detail about the Safe Drinking Water Act. But just for today's purposes, I want you to understand that it doesn't apply to, the Clean Water Act does not apply to drinking water. Now, there is some overlap between these two statutes because the Safe Drinking Water Act contains limited provisions for source water protection, whether that be like a reservoir on the surface or groundwater that's used for drinking. These provisions are minimal, and there are large exceptions. So, for example, when it comes to groundwater protection, there's an exemption from the regulations for fracking enterprises. So you could possibly argue that like the exceptions kind of swallow the rule. So today we're going to focus on the Clean Water Act. The Clean Water Act takes 3 steps to protecting ambient water quality. The first is the adoption of designated uses for navigable waters. Next, the adoption of water quality criteria to meet those designated uses. And third, anti-degradation measures to control pollution through permitting, inspections, enforcement, and voluntary programs. Sometimes you hear the term water quality standards thrown around. That's really a term that's referring to the combination of step 1 and step 2. So the designation of uses and then setting the water quality criteria to meet those uses. Okay, so I'm going to walk us through each of these steps. So designated uses means designating how the water body will be used. Okay, and thank you. I see your question. We will answer those questions towards the end of the presentation. So how will the water body be used? Well, some common uses are as a public water supply, which not surprisingly then would lead to stringent water quality criteria. It could also be for recreation, either swimming or boating. All sorts of economic uses, agriculture, various industrial processes, navigation. There could be more of an environmental focus. So protection of wildlife, propagation of fish or shellfish, and those could be either for human consumption or for protecting biodiversity. And sometimes the water body often will have multiple uses designated. So it's the EPA, or more commonly, the states with delegated authority, that designate the uses. And there's a role for public comment in this process. So there's often public hearings, opportunities to submit written comments, because the regulatory agency needs to understand how the public would like to use the water body. I will note that so the Clean Water Act directs the EPA or states to designate the use of all navigable waters. But there's a significant number of navigable waters that don't yet have a use designation. And so here's a couple maps from, I'm coming to you from Missouri. The top map shows all of the navigable waterways that have been mapped in the state. And the lower slide shows those for which there has been a use designation. So you can see for the major water bodies, a use has been designated. But for smaller, well, certainly for unmapped streams, but even smaller mapped streams, there just hasn't been enough regulatory resources to go through a designated use process. And so those water bodies without a designated use may have an inferior level of water quality protection. So for the waters where use has been designated, the next step is for the EPA or the state with delegated authority to set water quality criteria to safely allow those designated uses. And these could be numeric criteria. So a pollutant can be present in 3 parts per million, for example. Or they could be narrative standards. And these are common, such as the water should be free from odor, or free from scum or oil on the surface. Or it should be a certain color, or not a certain color, like it should not be neon green, which is indicative of a harmful alpha plume. So the EPA publishes tables, you can find these on the website, of recommended criteria based on designated use. So you could pull up, this is a water body for swimming, EPA recommends criteria. But like I said before, the EPA recommendations are a floor, not a ceiling. So states or tribes can choose to adopt stricter standards. Now I want to take us through anti-degradation. So I have a few slides here on permitting, inspection, and enforcement. You'll hear me talk about point sources and non-point sources of water pollution. So I wanted to distinguish between those two. A point source, I like to say, is something you can point at. There is like a pipe that is coming from the wastewater treatment plant or from a factory. directly into the water body. It's a designated spot. We could measure the affluent water quality at that point. We could install a pollution control device at that point source to remove contaminants. Then we also have non-point source pollution, which is more diffuse sources. So this could be runoff from agricultural fields. It could be, here we have rural homes that are on a septic or on-site sewage. Sometimes this comes from roadways or parking lots or building rooftops, where we can't exactly look, if we looked at the water, we can't tell you exactly what water is coming from where, but collectively, these sources are contributing runoff and often contamination to the watershed. So the Clean Water Act has been pretty effective at controlling point source pollution. The mechanism it uses is the National Pollution Discharge Elimination System, NPDES permits. And these NPDES permits are required for all point source discharges into navigable water. And for most polluters, this takes the form of numeric limitations. So those could be limitations on contaminants. It could also be, for example, temperature. Thermal pollution is something that could disrupt or interfere with the designated use. For wastewater treatment plants, that's a difficult business to be in, right? Because they don't know what the raw water coming into the plant is going to contain. Because we could all dump something down the toilet or dump it down the drain that could be unforeseen. Now, there is a program under the Clean Water Act for industrial facility pretreatment, which basically means if we have, let's say, a factory connected to the municipal sewer, then some pretreatment could be required at that factory, so as to prepare that wastewater for the general treatment process. But overall, treatment plants can't control what's coming in. And so that makes it hard to control in a numerical way what effluent quality is going out. So the NPDES permits for wastewater treatment plants are more often technology based. So they may say, there's going to be primary, secondary, or tertiary treatment. That could involve settling out solid matter, anaerobic or aerobic digestion of sewage, human waste, and other biological contaminants, or more advanced treatment to remove, say, nitrates or phosphates. So, as I said, overall, the Clean Water Act has been quite successful in controlling point source pollution. There are two programs that I want to highlight in the Clean Water Act about non-point source pollution. The first is the total maximum daily load, the TMDL approach. And this applies to, quote, impaired water bodies. And those are water bodies that consistently fail to meet the water quality criteria. So consistently are not safe to be used for their designated uses. In these impaired water bodies, the EPA, or the states or tribes with delegated authority, look holistically at all sources of pollution, point source and non-point source. They can put even more strict controls on existing NPDES permits and limit or suspend the issuance of new permits. From the non-point pollution side, what TMDLs often do is focus on voluntary measures. So these could be public education, this could be incentives for landowners to adopt best management practices, things to reduce runoff. So these kind of best management practices, so that could be, for example, in a cropland, installing a riparian buffer so that there would be vegetation and the farmed land does not go all the way up to the water body. If we think about suburban development, that could be installing rain gardens or rain barrels in individual homes. Or in the city, it could be, say, not salting the streets during storms, winter storms, in order to prevent that salt from running off. So, TMDLs certainly have led to many water bodies becoming significantly improved. I think there's something like around 700 water bodies where implementation of a TMDL has allowed the water body to meet the water quality criteria and be taken off of the impaired water bodies list. But these kind of voluntary measures only go so far. The Clean Water Act under Section 319 also provides for the nonpoint source management program. And this can be used everywhere, doesn't have to be an impaired water body. But basically it gives grants to states and tribes that design and implement plans for controlling nonpoint source pollution. States have broad discretion in the types of programs that they want to design. So a state program could be a regulatory program. It could be an incentive program. It could be an education program. Now the thing is with these, EPA does not have enforcement authority. And so because these plans are so different state by state, watershed by watershed, their efficacy varies. I know you can't read these, but just by way of example, you could go onto the EPA website and download some success stories. So one I have here is from the Illinois River in Oklahoma, which used basically provided grants to farmers and ranchers for using best management practices. The other one is from the Northern Mariana Islands, which is a protectorate of the United States, that focused on septic or on-site sewage and improving the capacity of those systems so that there was less runoff from rural homes. But there's also plenty of TMDL plans, 319 plans that are just kind of all talk and no action and don't lead to any improvements. When it comes to inspections and enforcement, so there are inspections carried out by the federal or delegated state tribal authorities. But I also wanted to note that permitted facilities are required to self-report the quality of their effluent using discharge monitoring reports. And some of the enforcement action taken under the Clean Water Act is to facilities that simply don't file their reports, or at a criminal level, facilities that falsify those reports. And you could say, well, that's just a paperwork violation. But it's not practical for every facility to have, regular visits by inspectors. And so these self-reports are a critical component to monitoring and enforcement. And so falsifying those reports can lead to significant harm. We'll come in a minute to citizen suit provisions. But when we look about enforcement at the federal or the state or tribal level, this can take the form of, say, a consent decree. I put a picture of one here from the city of St. Louis. These consent decrees are common in metropolitan areas that have aging infrastructure. And, it wouldn't really make sense for the EPA or for the state to slap a huge fine onto these municipal wastewater utilities, because the utilities are often doing the best they can with the rate that they collect. In some places we have declining population, declining rate base. And so taking that money in the form of a penalty would just further harm the environment by taking money out of the system. So these consent decrees are most often a schedule of improvements that the utility plans to make over time. This could be retaining sewage, like in a tunnel or a holding pen. It could be green infrastructure to reduce runoff. We'll talk more about that in a couple slides. Various other compliance orders or civil penalties, those are more directive from the regulator and not negotiated. And as I said, even criminal penalties. My last slide here is on dredge and fill permitting. So this is a requirement under Section 404 of the Clean Water Act that says a permit from the Army Corps of Engineers is required for discharge of dredged or filled materials into navigable waters. Now, there has been, as I said, for the past 150 years, an ongoing debate over what is a navigable water. And this arises, say, in the development context, where someone might want to build a structure on their property. And the question is, well, is there wetland and navigable water? What, in irrespective of that debate, what the statute says is the applicant must mitigate impacts where they cannot be avoided, do compensatory mitigation. So that could be like constructing wetlands elsewhere on the property. So we'll talk more about this navigable water definition in our current issues section. And so with that, I will turn it over to Dr. Panu. I'm happy to take any questions that are like immediate questions specific to my slides, but I want to make sure that there's enough time for her, and then we'll come back together as a panel.
Robin, there are quite a few questions that have come in, but I don't think any of them are going to be quick answers.
Okay.
So let's save them for the end.
Okay, very good. Thank you.
Thank you so much, Robin. No one has to call me doctor. I promise I have a Juris Doctor. So I don't know if that counts. But I wanted to talk a little bit about citizen suits, so a little bit about revolving funds, and then some environmental justice issues. And then Professor Rotman will join me again, and we'll talk about kind of emerging issues. I'm trying to keep an eye on the Q&A at the same time, so I apologize if I look distracted. I also have a tiny dog in the background, so if you see me looking off screen, I'm probably checking in on her. So one of the most important frameworks for enforcing the Clean Water Act are citizen suits. Generally speaking, citizens bring way more suits to enforce the Clean Water Act than we see from the EPA, for example. And there's a lot of reasons for that. But kind of the premise of the citizen suit provision, which exists in most of our federal environmental statutes, is that any person who's adversely harmed by failure to comply with the rules and permitting schemes or failure to take action to promulgate rules can bring a lawsuit to enforce the Clean Water Act if they can show that they've been harmed and if they can show that the government has not taken action. This is super helpful because, as most of us know, environmental harms tend to be widespread, although sometimes they're quite concentrated. But the folks who are regulated are very discreet and discernible. So it's a little bit easier for regulated entities to lobby and to engage in the process of trying to figure out how to deal with regulation. There's many fewer governmental attorneys who are doing enforcement in general. Oftentimes states and the federal government are overwhelmed by the amount of enforcement that they could do. And so citizen suits create an important kind of method to ensure that there's this kind of, we call it a private attorney general approach to enforcing environmental laws so that we can catch cases that might be creating a great deal of harm, but that the regulator might miss because they're looking at the national picture and maybe not at the more local or regional picture. So just for clarification, a citizen is any person. You don't have to actually be a citizen of the United States to bring a citizen suit, but you do have to show that you have an interest that's being harmed. That interest could be aesthetic. It doesn't have to only be economic or something else. It could be that you have always loved walking by this river. You walk by it all the time, and all of a sudden, you know, a coal slurry pit, you know, breaks down and dumps a bunch of coal ash into a river, and now the river smells, and you know it's aesthetically not beautiful, and I'm sure there are water users who also can't drink the water anymore. So that's the kinds of things that can come up in a citizen suit. Another example could be you have sewage backing up into your home because of a failure of the sewage treatment system. Usually that's run by a municipality. So there's lots of different kinds of citizen suits that could be taken, and you can bring it against anyone, including governments, insofar as the 11th Amendment allows you to do that, or in cases where the EPA administrator is required to take action and has not done so. So let's go to the next slide. Here we go. So to bring a citizen suit, first you have to give notice to the EPA, to the state where the violation occurred, and to the U.S. Attorney General. You give them 6 days notice with a copy of the complaint you intend to file. And the purpose behind that is to allow the state or the EPA / Attorney General to step in and enforce if they realize this is a big thing that they missed or it's something that they feel like needs enforcement. You also have a right to intervene if the United States is reasonably prosecuting a case in civil or criminal court. What makes this tricky, though, is that because you're bringing the case in the name of the government has the right to intervene at any point. I'll just tell an anecdote, but I was working on a case that involved a similar analog under state law, and one of the major things we worked on was trying to keep the state attorney general from intervening. And the reason was that we knew that the state attorney general was willing to settle for a resolution that would not actually solve the environmental problem that the plaintiffs were upset about. And so this happens also right now. So, when you have a federal administration that has different priorities than perhaps the priorities of the folks bringing the citizen suits, same for a state government, it can be difficult to bring a citizen suit because they can intervene and sometimes kind of send your case haywire. Most of the time they don't, they just don't have the capacity, but it depends on how politically motivated the parties are at any given time. And they can also intervene after you've won, which is very frustrating. So just something to know. So as I mentioned, citizen suits matter because they play a critical role in covering our environmental protection, and they fill gaps, both resource gaps in terms of the lack of staffing at the federal level and political gaps. So sometimes, a state might not be enforcing environmental laws for political reasons. Environmental protection used to be very bipartisan, but in the last 20 years especially has become incredibly polarized. And so sometimes you'll have states that just refuse to take action or federal regulators who won't take action. The other thing it does is because regulators are faced with so many rules and so many permits that they have to process, sometimes a citizen suit can nudge them to take action on something that's been sitting on the shelf for too long. So if a bill passed and Congress told them to undertake the rulemaking process and promulgate rules within 2 to 3 years, and now you're 10 years later and you have no rules, sometimes a citizen suit, that would be untimely, but a citizen suit can help nudge that process. And sometimes the penalties will provide an incentive for the polluter to come into compliance. So the penalties, depending on the size of the polluter, can be considered to be quite small or quite large. How we each view money and money penalties depends a lot on what's in our bank balance to begin with. But sometimes the cost of coming into compliance is going to be cheaper than the cost of paying penalties. And so the citizen suits can provide that financial nudge as well. And certainly coming into compliance almost always will be cheaper than the cost of litigation. So I found this cool map. It's a little outdated, or graph rather, and this is all the different citizen suits cases that were filed between 2001 and 2016, I believe. So a little outdated, but the most recent data that I could find. What I would like you to take a look at is this gray-blue kind of thing. I don't know if you can see my cursor, but at the very bottom of the stack is light blue. Those are Clean Air Act cases. Right above that is a dark slate blue gray. Thank you for whoever's cursor did that. That's the Clean Water Act cases. If you look at those two groups, they make up the majority of cases. And in some years, Clean Water Act citizen suit cases are the highest number of cases that are brought. There's a bunch of analysis on which states they're brought in, but perhaps you may be surprised to find that Tennessee, for example, is a top 10 location of these kinds of suits. So they're not exclusively limited to places like California, which brings the most citizen suits in general, but also has the highest population in the country. So with that, here's a shaky jump take to revolving funds. So we have all these enforcement cases, we have all these issues. So how do we pay for fixing problems? Most clean water infrastructure, if it's not affiliated with a facility, for example, usually has to deal with sewage systems and stormwater and gutter systems. And those are almost overwhelmingly run by local governments. Most local governments are not very flush most of the time. And so with the kind of advent of let me rephrase this. So the federal government used to spend a lot of money on infrastructure. They helped underwrite some of the massive sewage creation and sewage build out systems in the late 1800s. Then there was a big infusion right after World War II. And then, from the 1970s onward, the federal government has been consistently clawing back its funding. And we've seen that in lots of areas of infrastructure. So now you have cities that have sewage systems that are 150 years old, or they have stormwater systems that are super old. So as those systems began to fail, because they need to be repaired usually every 40 to 60 years, depending, and most of them have not been repaired or replaced. We got the creation of the Clean Water State Revolving Fund and the Drinking Water State Revolving Fund. So the Clean Water State Revolving Fund was created first, and then the Drinking Water State Revolving Fund. And this is another example of cooperative federalism, but on the kind of carrot side. So we talked about, the sticks of enforcement and permitting and regulation, but the carrot side is trying to make up for the lack of federal funding that has been in the mix for a very long time. I gave you a non-exhaustive list of things that the Clean Water State Revolving Fund funds, but I think it's helpful to just know that the vast majority of projects that you think of when you think of a water project are going to be funded under this. They're not going to be funded under the Drinking Water Revolving Fund. Treatment works, by the way, is just a nice way of saying like a water treatment facility or a sewage treatment facility. But it also covers wetlands, water conservation, estuaries. So we're thinking of a more comprehensive kind of view of how we're using water. If we go to the next slide, then here are the major types of aid that the revolving funds provide. They provide low and no interest loans. So by law, they have to give you a loan that's below the prevailing prime interest rate. And that's supposed to help make funding available to cities that can afford debt service, but could not afford it at a prime rate, and counties as well. You can purchase your debt and refinance it for a lower rate through the Clean Water State Revolving Fund. Sometimes they will use the fund to provide a guarantee for someone who is obtaining funding on a different market, or they serve as a guarantor for insurance. There's a small number of grants, and you'll see in a moment why grants are not as common. And then there's also principal forgiveness. So they can't forgive the interest that you're paying on the loan, but they can forgive the principal on the loan. So here's how the fund works. So revolving funds are exactly what they sound like. It's a fund where you give out money and then money comes back, and that helps you keep giving out money. So it's replenishing itself. So the federal government provided the initial capital to all the states who opted to use the funding. States then have to put up 20% of the funding in their own money, which they did. And every year they adopt an intended use plan. So if you're really interested in what kinds of projects are funded, I would say participate in the administrative advocacy process for the intended use plan, because it will show you what things are prioritized or deprioritized. Intended use plans have had a massive effect on things like suburbanization, inequality in the distribution of income, because shrinking cities are not seen as being as credit worthy as growing cities, and that has a lot of racial and socioeconomic baggage that's often attached to it. So over time, the intended use plans become an important way for thinking kind of at a policy level about structural problems and how we've built out our environment. So then the states who manage all these funds, so you don't apply to the federal government for this money, you apply to your state. The state then takes the federal money, they take their match, they package it all together, and they create a bunch of financial products and grants. So they do the low interest loans and the other aid, and they provide it to local governments, schools, sometimes to private utilities, but very rarely, and then to nonprofits. So generally speaking, they're trying to fund folks who fall in the nonprofit sector, either as, 501c organizations, or local governments and other kinds of small, not-for-profit, publicly owned groups. Publicly owned meaning owned by a government, not owned by shareholders. And then when folks repay their loans with the interest, they use that to replenish the fund. Every now and again, there's a new cash infusion that comes in from the state and from the federal government. For example, there are states that have adopted green bonds, and they might put the funds from the green bonds into these revolving funds. But that's where the money comes from, and that's ideally where we're supposed to be funding folks. As a practical matter, the need for these funds far outstrips the amount of money that are in these funds, which was one of the things that the bipartisan infrastructure bill was aiming to address, although its funding has now been clawed back or put on hold. All right. So with those things in mind, I thought it might be helpful to think through a couple of environmental justice case studies of where the Clean Water Act doesn't necessarily reach or where it might be difficult. So environmental justice, broadly speaking, is concerned with procedural justice, recognitional justice, and the distribution of environmental goods and bads along axes of inequality or diminished political power. So I thought Lowndes County, Alabama would be a great example. So Lowndes County was subject to a federal environmental justice investigation. The Biden administration preliminarily found that there was a history of racial discrimination in terms of who the state of Alabama and who Lowndes County was giving funding to for the creation of sewage systems. One of the things that's really difficult in Alabama is that they have a really clay-heavy soil. But they also have a lot of folks who are on what we call non-networked sewage, which means you don't have a sewage treatment plant with pipes. You have septic tanks in your backyard and, a leach pond. So here are examples of what happens in Lowndes County, not only when it rains, but also anytime like there's any kind of difficulty in someone's system. So this is a mobile home on the left-hand picture is a mobile home where raw sewage has backed up. And the right-hand picture is one of the sewage ponds. That's just like relatively raw sewage. There's a filter that captures like solid waste, but the solid waste is going to break down and enter into that stream over time. And it just sits there in the open sun all day. So imagine sitting next to like a raw sewage pool all day. Certainly not healthy from an environmental health standpoint, certainly not good from an environmental standpoint either. And super, super risky. Having raw sewage in your home is like horrific. The number of children who've been exposed to waterborne diseases in Lowndes County like rivals developing countries where there's no infrastructure, which is just shocking and horrific. Then when you overlay that Lowndes County is majority Black and that there's a pattern of not giving funding to counties that are Black over counties that are white, regardless of their tax base, it becomes pretty ugly. So the state revolving fund has not touched Lowndes County, for example, since its creation. I would I would encourage folks to take a look at this if this is of interest. There's a lot of really great research that's been done on it. Alabama has said the Biden administration committed money, the Trump administration revoked the money. The state of Alabama has said it's going to address this issue. It's a really tricky issue. I mean, so for folks who know how septic leach ponds work, you spray like semi-treated, it's not, treated with chemicals, but it's like semi-filtered wastewater onto grass, and it's supposed to, percolate through the grass and clean itself. When you have clay-based soil, it's not going to percolate. It just sits on top. Clay doesn't absorb water very well in this context. So just something to think about. So the Clean Water Act in this context is not touching Lowndes County because Lowndes County is on septic, not on sewage. The other thing that makes it really tricky is because folks are generally more rural in character, it can be more expensive per person to build piped infrastructure. Doesn't mean you shouldn't do it, but there are places in Lowndes County that are more densely populated and places that aren't, and that can impose different kinds of costs. And over time, our tax policies in many states are designed so that the people who get the infrastructure have to pay for it. It costs about $400 million, or it did before COVID, so I'm sure it's more now, to build about a quarter mile of sewage pipe. Once you take into account the planning, the engineering, the permitting, and all of that. So imagine trying to have to pay for that if you're living below the poverty level and there's 3 homes. Like there's no way anyone could ever pay that, so that folks end up in a stuck area. Another great example of this is McDowell County in West Virginia. McDowell County, also historically Black, which most folks are surprised to hear about for West Virginia, unless you're from West Virginia, and then you know this quite well. West Virginia and parts of Kentucky, all throughout kind of Appalachia, have a major problem with what we call straight piping. So generally, these pipes should be subject to the Clean Water Act, but as a practical matter, it's not really enforced because what is the enforcement solution? So what ended up happening is when coal companies came in to do mining, they also built housing for the coal miners. And so a lot of that housing is on these super small lots. As you can see, these lots don't have like a lot of frontage between the back of the house and the stream. They also don't have a lot of room between themselves, which means there's no room for septic. So what they do instead is when you flush the toilet, I don't know if you can see these little pipes, these little black lines that are coming out of the stone wall and just sinking straight into the river. That's what happens. Raw sewage goes through that pipe directly into the rivers and lakes. And it creates a massive kind of issue in terms of not only like pollution and public health issues, but also it's really difficult to solve this when there's no place to put septic. So you can't solve it by just sinking septic. It's not good terrain for septic tanks, but also there's literally no place to put it. So instead, what folks have done, once this company housing was built, once the coal mines left, they never fixed the housing, they never upkept the housing, they never brought it up to code. And you've got folks who now have no jobs because the mines are closed. And there's not a lot of other employment, although that has changed substantially in West Virginia in the last 10 years. But historically, you had folks who were essentially trapped. They couldn't move, they couldn't sell their home, and they had these straight pipes. So another place where the Clean Water Act could reach, but enforcement was the only tool folks could see. And so they couldn't figure out a way to kind of to move forward. And really the way to move forward with this would be a massive infrastructure project. But again, West Virginia is more rural in character. It's one of the most impoverished states in terms of Appalachia is one of the most impoverished regions. The state's not impoverished. It's of course got very rich history, very rich culture. But again, it breaks along both socioeconomic and racial lines. I thought it would be helpful to mention a city as well. So I thought I would bring you to New York, which is where I'm based right now. So one of the communities that I work with pretty extensively is out in Queens. All of New York is on what we call a combined sewage and stormwater overflow or outflow model, which means our sewage system is connected to our stormwater system. So anytime it rains, raw sewage backs up into people's homes in Queens. I think folks saw some photos of this on the news. You definitely see it during hurricanes. So like Hurricane Ida, we had this. And for, sorry, I got distracted by good questions in the Q&A. So we see this during hurricanes and when there's storm surge, but it happens anytime there's like a ton of rain. And with climate change, what we're seeing in New York is a large amount of rain by New York standards over a small amount of time, and it overwhelms the sewage system. When it overwhelms the sewage system, what ends up happening is we not only get raw sewage on the streets, overflowing and creating all sorts of health risks, but folks who have basements, which is often low-income folks in these communities, they end up getting completely flooded out, and sewage backflows are not usually covered in your home insurance. So this creates massive social justice issues. New York, the city of New York is under a consent decree, and so is the state regarding its combined overflow system. But the consent decree was signed almost 10 years ago, and we have seen flooding as recently as this last year. So it creates massive issues, and the communities that's mostly located in are mostly lower income Caribbean, Latina, and Black communities that I would analogize to being similar to the Ninth Ward of New Orleans, where folks own their homes and there's a very rich cultural history and like immigrant history and kind of native like I've forgotten words, but essentially there's a strong community there of folks who've been very resilient and have done a lot of mutual aid over time, but have not really received kind of the benefits that we see in the slightly higher income and wider neighborhoods, for example, in Brooklyn, where there's been this flooding too. And my last example is the Navajo Nation. I thought this was important to include because tribal communities overwhelmingly are less networked. Sorry, one moment. Oops. And have less access to running water and sewage than other communities. In Navajo Nation, that percentage is as high as 30 to 40% of folks living in the nation do not have any running water or sewage system. This is the Navajo Tribal Utility Authority's treatment plant. It was sued by the EPA during the Biden administration and entered into a consent decree. One of the things that's so difficult in tribal communities is accessing the funding that they need and having the technical support and expertise in order to, I mean, they have it, but to be able to get it at the scale they need it to get it to serve their community. Navajo Nation is the largest nation, and so a lot of the issues that we've seen in other smaller nations can be seen on a much larger scale here. But the Clean Water Act is relatively new, I would say, to the Navajo Nation. Nations can decide whether to adopt or apply certain standards, and they've applied and they've done their best, but it's really, really tricky. And they also are surrounded with a lot of really, really unique contaminants, like contamination from silver mining and from uranium mining that is extremely difficult to treat and particularly difficult to treat when you're spread out across 4 states. All right, breather. But I thought it would be helpful to talk a little bit about current issues. So I'm going to hand things back to Professor Rotman to talk a little bit about non-point sources in the context of agricultural pollution in particular.
Great. Thank you so much. And I've been trying to answer a couple of the questions. Certainly so many good ones have come in. So in the current events section, we're going to cover a few different things like PFAS and emerging contaminants, the waters of the US definition. And what I want to tackle is agricultural non-point source pollution. I wanted to discuss a case which is from the Iowa Supreme Court called Board of Water Works Trustees of City of Des Moines. And this was a case that was brought against upstream irrigation districts. So basically we have a photo here of the city of Des Moines. Certainly Iowa is a large agricultural producing state, both in terms of crops and animal agriculture. And being a fairly flat state, a lot of the irrigated area uses tile drain systems. This is an image from the Iowa state government website that shows how a tile drain system operates. So basically, as the water, irrigation water percolates through the soil, it then descends to a level of tiles, and those tiles convey it outward. Now, you would think that this sure looks like a point source, right? Because there's a pipe where you can see that this is the agricultural drainage being discharged to the water body. So this case raised an important question about whether this is a point source or a non-point source. The context was that the city of Des Moines, one of its leading water sources of raw drinking water is the Raccoon River. And the water quality criteria were significantly exceeded by, I think, about a factor of 4 for nitrogen in light of the upstream agricultural operations. And this was causing the drinking water treatment costs and therefore the consumer rates to rise significantly, needing really like a next generation type of treatment system. So the city sued the upstream drainage districts in a Clean Water Act citizen suit. It brought this theory of the tile drains being a point source rather than a non-point source. In the end, in this case, the Iowa Supreme Court ruled in favor of the drainage districts, but it was on a state law grounds that had to do with sovereign immunity. And it didn't reach the merits of the question as to whether, one, whether this could be a point source, and two, whether the upstream drainage districts could be held responsible. There have been other cases in other jurisdictions where drinking water facilities are trying to recover costs from upstream operations. I mentioned earlier that there's some synergy between the Clean Water Act and the Safe Drinking Water Act, and this type of source water protection is one example. So I just wanted to highlight that case. I'll hand it back to Dr. Panu, and then yes, thank you. Yeah, I'm glad that you're familiar with the case. So and then we'll open it up for questions.
Yay! Okay, we're nearing the end, I promise. So I wanted to touch on a couple of Supreme Court cases that you've probably heard of, and some of which have come up in the chat and in the Q&A. This is a map that was generated by Earth Justice right after Sackett versus US EPA. Sackett was the Waters of the United States case. The case had to do with wetlands and wetlands that are connected kind of through different systems to what we would consider navigable waters of the United States, including intrastate lakes and then the rivers that flow through them. I thought it was really interesting that they have flagged for us places that are really important in terms of wetland provision, but that have relatively weak laws, meaning that usually their laws are set at the federal standards. So in some states, I'm a Californian, so I'm super biased, but in some states like California, we have water protection laws that go beyond the federal standard. The federal standard is kind of the floor. But there's a lot of states in which, wetland protection is not a priority in the same way. It is not surprising that the Gulf states are all, except for Florida, are all ranked relatively low. Part of that is because of the petrochemical industry and the amount of drilling we do in the Gulf of Mexico. So I think all of that's really helpful. In Montana, a lot of it has to do with mining. Sackett, I think, is going to continue to be a difficult case. One of the things that I think is so challenging about water law at the federal level in general is that the ecology and hydrology of water doesn't match the political way or the legal definitions that we have. And that's going to continue to kind of bump up against one another like it did in Sackett. Yeah, and it's going to come up again and again, especially with climate change. And so as water becomes, or areas become dry and then wet and they're not constantly flowing, I think we're going to see a lot more coming up in this area. I would be surprised if someone wants to bring another case like this to the Supreme Court, though. I think the decision in Sackett was pretty rough, depending on your viewpoint and where you're located in the country. But one of the things that I think is so difficult about water law is that the geography of water is also so very different depending on what region you're in. And the role of the federal government in the provision of water is very different. And so sometimes that gets missed by the Supreme Court depending on where the justices are from. Okay. Oh, yeah. So this is a slide on narrative standards, which I have summarized as poop in the water. So this is San Francisco, City and County of San Francisco versus EPA, which was decided earlier this year. This was a lawsuit about a combined sewage stormwater system and narrative standards. So Professor Rotman told you a little bit about narrative standards earlier. For example, that the water should not smell a certain way. So the way that California uses these standards is that it has a general provision about not degrading water. And so it's called an anti-degradation standard. One of the things that's difficult for cities everywhere that are on combined sewage and stormwater is that they will almost always have an overflow that exceeds their permit or otherwise violates their water permit during major storms or during kind of catastrophes. And as weather becomes less and less predictable and more extreme, it's difficult for them to take on the cost of that. So here we had a really sympathetic plaintiff, San Francisco, that had already invested millions of dollars in this and basically said it's going to bankrupt our budget if we try to redo our entire sewage system. And basically said that narrative standards are vague. I disagree with the Supreme Court and the city of San Francisco on this, but I think it's helpful to see how widespread these combined systems are. These are all systems that are over 100 years old. They're primarily concentrated in the East because by the time we got to the West, there had been an evolution of time and we split our stormwater systems in a lot of places, but there are some really big cities like Seattle, Portland, San Francisco, Sacramento on the West that are also on this system. So keep your eyes open for this. The issue was about poop in the water, but the real kind of legal issue is going to be about these narrative standards and how applicable they are. In San Francisco versus EPA, the Supreme Court kind of threw out the idea of narrative standards for vagueness, although it didn't fully overturn narrative standards if they were perhaps more specific. Oh man, I came up with all sorts of things. So 2 more slides. The kind of big issue really right now in water treatment is PFAS, which are PFAS, PFOS, PFOA, which are forever chemicals. These chemicals are really difficult to treat and to get out of your water, and they're very costly. And as you can see, they're ubiquitous. This is a map from the Environmental Working Group showing all the areas where there's been water testing with PFAS that is at or below the drinking limit. I think this is going to be a major issue for water affordability going forward, and so we'll see how that affects things. But it's affecting ecosystems as well. It's not just drinking water, although that's where it's going to be the most expensive to treat. It's kind of everywhere, and they're carcinogenic and have all sorts of other negative health effects. And so, we were about to undertake rulemaking under the last administration. I don't know if anything will move under the current administration, but we're seeing states begin to move into this regulatory space. Which brings me to my last slide, which is about the role of states. This is another Earth Justice kind of guide to show examples of states that either rolled back or expanded wetlands protection right after Sackett. This is not comprehensive, but I thought it's a good example of what's been done in the clean water space. There's a number of states that had these trigger provisions that said that if the federal like their water standard will not be stronger than the federal system, they link it to the federal system. So when the Supreme Court has a case like Sackett and rolls back protection for, hundreds of thousands of acres of wetlands, the state has like kind of hooked itself onto that. There were also a number of states that introduced measures to tie their state standard to the federal standard. Not all of them passed in 2024, and those are the kind of pastel mauve states that you see. Other states made their definitions more expansive. So California and Washington and New Mexico, for example, expanded their definition to step up. Now I think we're going to see kind of fighting over who has primacy over wetlands, but states have authority over their lands outside of the navigable waters framework of the federal constitution. And a lot of states have public trust doctrines that cover some of this environmental protection. The other thing we've seen a lot of is the adoption of environmental rights provisions in state constitutions. Some states have had them forever, like Montana and Pennsylvania. They've had them for over 30 years. But other states are newly adopting those provisions. And I think we're going to see a lot more state action as we see the federal government kind of roll back and as we see the federal courts roll back too. So this is a really fascinating area of study. I'm a person who always is very excited about state and local innovation. So I feel like this is a really great place for folks to think about their advocacy now that we see like kind of the doors closing a little bit at the federal level. And with that, I think we've reached Q&A.
All right. Well, thank you both very much. That was a lot to cover in a very short amount of time. And we have lots of questions to get to. First of all, I would say for any of you, there have been some answers to questions via typing. And if you open up the questions little tab there, you should be able to see the answers to some of the questions that have already been given. I've got a few of them that I might just drum up to see if there's anything else that folks that Camille or Robin would like to cover in those. But real quickly, I'll try to go with some of the most recent ones and then get to some of the bigger questions that were asked earlier. So Camille, going back to your slide with regard to current issues, the wetlands protection, it looks like this was an Earth Justice 2023 map. There was a question of how that was basically determined, what the states on the slide that have the least protected wetland laws. Do you know how the methodology basically for making that determination?
Oh, no, I would have to ask Earth Justice. All I know is that they did like a comprehensive 50-state review, and they were tracking legislation to see which of these states had trigger laws. Sorry, trigger laws are like laws that go into effect once a Supreme Court opinion comes out a certain way. So most of these states are states that had trigger laws where the standard went down to the federal level if the Supreme Court overruled a certain case. And so that was the case for WOTUS. So these were all states with laws connected to the definition of waters of the US.
Okay, great. One other quick one, a New Yorker was asking you out of curiosity, are there areas of Queens that are more impacted than others? And if so,
yes. Southeast Queens is the most hard hit by these flooding events, and then the Rockaways are hard hit by storm surge, although the Rockaways are closer to Brooklyn sometimes. But yeah, so Southeast Queens meaning like Rosedale, St. Albans, South Jamaica, South Ozone Park, down by the JFK airport. There's about 15 communities and like neighborhoods down there that are more hard hit and are lower lying. They also are not designated as being in a floodplain. So most of New York City is considered to be in a floodplain, so you qualify for subsidized federal insurance. Southeast Queens is not. A lot of Queens is not designated that way. So not only are they harder hit, they also can't get subsidized insurance.
Thank you. I'm going to pair a comment with a question that came in. The comment was, relying on citizen suits to enable enforcement seems akin to cleaning up downstream pollution instead of upstream point source or process improvements. The question from another attendee was, do you foresee an increase in citizen suits given the current administration?
That's a great question. Honestly, I don't. And I can tell you why I don't. It's twofold. The first is that I think people don't want to litigate the case up through the federal courts to the Supreme Court. So there's a lot more strategy going into whether or not to bring a case because you might get okay law at the appellate level, but you would get bad law at the federal level, or sorry, federal Supreme Court level. What I've been seeing folks do instead is turning back towards state law to see if they can stay in state courts to bring cases. A lot of states have citizen suit provisions that are analogous to the federal provisions. The other reason I don't foresee this going up is because there's a finite number of Clean Water Act attorneys in the country who bring cases on behalf of plaintiffs. And the number of folks who are on like kind of the public interest Clean Water Act side doesn't have a lot of funding. So that number doesn't change substantially. It doesn't go high up unless there's like some kind of crisis. So yeah, I assume it will probably stay around the same. It might go down a little bit.
All right, I'm trying to monitor the chat as well because there's some questions coming in there as well as in the questions box. So I'm going to try to get to all of them. There's a question about how does navigability differ at the federal versus state level? And that might be a little more complicated of an answer than it might seem, but either of you like to tackle that?
Yeah, I can go for that one. So the concept of waters of the United States or navigable waters that are used in interstate commerce is a question of federal law. What I think is maybe embedded in this question, though, is if we look at individual states who are operating with delegated authority, for example, the permitting and enforcement provisions of the Clean Water Act, the question is, could they require NPDES permits for point source discharges into non-navigable waters, ephemeral water bodies that are not or allegedly not hydrologically connected to the interstate water system? Sure they can, because the Clean Water Act again sets the floor and not the ceiling. And so if states in their delegated programs want to impose more stringent criteria on water bodies within the state, they have the freedom to do so. But state law is not going to define what a water of the United States is.
All right, thank you. Let's see. If the original goals of the Clean Water Act were for all navigable waters to be safe for swimming and fishing, then did all navigable waters automatically have recreation and fishing as designated uses?
You know, I didn't want you to raise that one, Adam, because I don't know the answer. That's a great question. I'm going to take a guess, but I'm not sure, which is no, because we still have water bodies for which there has never been a use designation. I would also say that these water quality criteria recommendations have evolved over time. And so even if they were, let's say, the day the Clean Water Act is passed, even if every water body were to be designated for swimming and fishing, at that moment in time, there was no corresponding criteria, right? It took decades for those to be developed. So I see this as more of an aspirational, same like the idea of we're going to totally eliminate discharges of pollution to navigable waters. This was, in the part of the statutory text that was expressing statutory intent rather than explaining how specific permitting would operate.
While we're sort of on this subject, I didn't know if there's anything else you want to add with regard to that question concerning WOTUS versus undesignated water bodies.
Oh yeah, okay, sure. So I had answered that, but I'm going to, and now I can't find the answer, but I'll just talk about it. Okay, so the question was like, well, isn't this whole WOTUS issue meant to address on water bodies for which there's not a designated use? What I would say in response is if you take a state like Missouri, there are many water bodies where there simply hadn't been the regulatory resources to designate a use and to conduct that public process. So like nobody was saying it wasn't a navigable water. Nobody was saying it wasn't a WOTUS, but there just hadn't been the resources to designate the use. so I think that what the WOTUS issue does is define, which water bodies need to have a use designation. And a more expansive definition of WOTUS would say more water bodies do. A more restrictive definition would say fewer do. But even among a very, like, let's say you take the navigable in fact definition, a strict interpretation. There are still many water bodies that just we haven't gotten around to it yet.
I've got two questions that I don't know how familiar either of you are with these topics, so we'll give it a shot. One is UAAs. Can you explain how a use attainability analysis is applied and the legal basis for doing so?
Do you want, I can have a go at that. Yeah, and then come behind me if I miss something. So yes, okay, so when we come, and actually I saw this question come in and I pulled up a slide. So this is a slide off of EPA website that discusses designated uses. And basically the idea is that we could have a desired use, let's say drinking water supply. But sometimes that desired use is just not attainable. I didn't include this graphic in my presentation because I sort of disagree with parts of it. So what can happen is that maybe we say the desired use is public drinking water, but the highest attainable use maybe is just recreation. Okay, it's not realistic to get the water to meet the water quality criteria for drinking water. Okay, and so that could be due to factors, limiting factors. One is naturally occurring pollutants. You could say that applies in some areas to radionuclides, to arsenic. We're talking about the bedrock geology through which the water is flowing. And there isn't an expectation that from a Clean Water Act standpoint that a water user would have to clean up more than their pollution, right? Like we use the natural condition as a background. I could also see here it says physical conditions of the water body, and maybe that ties into low flow, maybe some things like turbidity or suspended solids, or odor. These are things that just the geomorphology dictates. The reason I didn't put this slide up is because like human caused conditions, economic and social impacts. I mean, I would argue that those may be a bridge too far. It says like, okay, the water can't be designated for the use you want because of human caused conditions. Well, the whole point of the statute is to help clean up the waters. And while there are economic and social costs to be considered, sometimes cleaning up the water costs money and can impact people. So the long and the short of it, I would say, I'm gonna show one other graphic that I also didn't include. This is from the EPA website that talks about the designated use process. This is the state version, but they have one for tribes as well. And so, it's what would be the desired use? What is the highest attainable use, which could be lower, and that would be documented through the attainability analysis.
Camille, is there anything you want to add or go to the next question?
No, I thought that was really good. I liked the graphic especially.
All right, next one is in lieu fee programs. I don't know if either of you have much experience with that. I wish I could channel my colleague Becky Kisslinger because she would definitely have a good answer to this one. But the question is, how effective is compensatory mitigation like in lieu fee programs and permittee responsible mitigation in achieving the Clean Water Act goal of no net loss of wetlands?
I mean, I would say generally that, natural wetlands are typically the most effective. And a constructed wetland is almost inevitably not going to be as effective at flood attenuation, at habitat, at pollution mitigation as a natural wetland would. Also, the location matters. So like if we do, let's say a wetland mitigation project out in the middle of a rural area, so we're going to put in a big wetland. But maybe there isn't that much pollution in the area. So the wetland is attenuating what little pollution there is, but that same footprint, like let's say it's 1 acre, if we had that in an urban or suburban environment, would have a much greater impact on the water quality. So I would say, and some of this is an engineering question about how to engineer effective constructed wetlands. But by and large, we're kidding ourselves if we think that it is truly a one-to-one comparison.
Anything you want to add to that, Camille?
No, Robin got it. I mean, ideally, we want to keep the wetlands that we have to the greatest extent possible. There are some examples of not constructed wetlands, but like mutually beneficial wetlands. So for example, farmers building in flood zones and then like keying their crops to the kinds of crops that are also adjacent to wetlands so they don't have to remove the wetlands or harm them through pesticide provision. So there's some projects that are more cooperative that seem to be effective, but for the most part, wetland replacement has been less effective than if we can preserve the wetlands we have.
Question about some of the key sections of the Clean Water Act. Can you speak on Section 401 of the Clean Water Act and how it compares to Section 402 and Section 404?
Sure. Well, in brief, so Section 401 is a water quality certification, and this requirement pertains to federal activities. So if there's some kind of federal project, the state or tribal governments who are impacted would either need to issue a 401 certification or waive their right to do so. 402 is the NPDES program, and that applies not just to federal projects, but to all point sources of pollution. And then 404, again, applies to private citizens, and that's the dredge and fill requirement.
Great. There was a comment that we at FEMA have been reviewing floodplain mitigation grants for wastewater treatment plants projects all the time. So just wanted to throw that one out there for everyone to hear. It's actually a question that I'd like to take. Where and how do water rights fit into all of this? So you may have seen in the questions, there was a previous question with regard to uses and whether there was a priority among uses. And the very short answer on that was basically water allocation. So who gets to use water, when and where, and for what purposes, especially if you're out west, is primarily run by state law. The Clean Water Act focuses on water quality, and we might get into this a little bit in some of these subsequent questions, but pretty much surface water quality. So the states are primarily the ones that that control who get water allocation. There are some exceptions to that. There can be federal contracts with the Bureau of Reclamation, et cetera. There can be more local allocation schemes set up through ditch districts, et cetera. But for the most part, the states have a lot of influence over who gets what water when. There can be conflicts between the Clean Water Act and water quality, as you might guess. If there are low flows, there can be rising temperatures and rising water temperature. There can be lower dissolved oxygen levels and so forth. Obviously your aquatic life uses can be severely hampered if you basically have a dry stream. So there are conflicts there. The Clean Water Act is a federal law. It's the law of the land, but there are also politics involved in all of this, as with many other things. And water rights are a very heavily protected authority among the states, as well as private rights. I'm glad to get into any of the details in terms of prior appropriation versus riparian rights and some of the hybrid structures and so forth that are out there. But there are certainly intersections. Naturally speaking, there are tremendous intersections between the two. practically speaking, they are pretty siloed areas of law that do intersect, but there's even a provision within the Clean Water Act. It talks about where some of those limitations are in terms of the Clean Water Act vis-a-vis water allocation schemes and individual water rights. So they're connected, but there are also gaps. Anything either of you want to add to that?
No, but I have something totally different.
Okay.
There was a question posed right after my remarks that really was more of a clarifying point
Mhm.
that I just wanted to make sure everyone was aware of. So I was talking about non-point source pollution, and I said that one example could be like urban runoff from rooftops, parking lots, waterways, and so forth. And what the commenter very aptly noted is that in some urban areas, there is a separate stormwater collection system, right? So not the combined sewer overflow, but separate stormwater systems. And that those then are collecting the stormwater, and those are treated as a point source. So when I'm talking about non-point source pollution in the urban environment, I mean at like a diffuse level. But if there's some kind of collection infrastructure, then that becomes a point source. So thanks for the clarification.
To add to that, concentrated animal feeding operations also are point sources, but because of terminology in the definition of, was it definition of point source, that ag lands, even if crop lands, even if it does go to a specific conduit, are not included as point sources. All right, what complexities are we going to see given changes in NEPA requirements across the country? Will states have to take over via a patchwork framework?
Well, I'll say something and then maybe Professor Panic can help me out. Let me pull up the question to make sure. Well, I'm not sure where the question is, but I mean, what I would say about NEPA, right, is that so now we have this like decentralization of NEPA. So the Council on Environmental Quality is basically gutted. It will no longer issue guidance on how to conduct the NEPA process. Each federal agency will conduct it on its own terms. And some agencies have now released what their approach would be. At the same time, we've seen clarity regarding NEPA, say in the 7 counties case in Utah, that indirect and cumulative impacts of a project do not need to be included in the analysis. So in that case, that was like a proposed railway that would have taken coal from a part of Utah. And the question was, does the NEPA analysis just need to consider the impacts of the train line? Like we're gonna lay the track, we're gonna have a siding, maybe that interferes with migration or whatever. Or do we also need to include the impacts of burning that fossil fuel that will be brought to market via the railroad? Right, and so the Supreme Court held that the NEPA provisions are narrow. You only need to look at the direct impact of the project. So on the whole, I would say this is a weakening and a fragmentation of NEPA at the federal level. I think about 26, 27 states have a SEPA, like a State Environmental Protection Act, that could require a more extensive analysis. My own take on NEPA, though, is, NEPA is a process statute. It's not outcome determinative. And so, I don't know how much good NEPA was ever doing. And so rolling back these provisions, I'm not sure if we look at on the ground environmental quality, how much of an impact this will really have.
Yeah,
No,
NEPA's a mess. And just to tag on to what Professor Rotman was saying, there was also an indication in that in the Utah case that the Supreme Court is satisfied with NEPA being graded on completion, not accuracy. Like if you go through the steps, you get credit even if the steps are not everything they should be. And California just went through a massive rollback of its state NEPA equivalent, which is depressing or exciting, depending on your political stance on whether that has been an effective statute. I do think that NEPA comes up a lot for those of us who like live in areas with reclamation projects and for tribes, and for folks with levies. So anytime we've got the Army Corps, NEPA becomes really, really important, or anytime we have like tribal sovereignty issues. But I do think it's going to continue to be messy. I don't have any idea how anyone could do a NEPA analysis with all the guidelines revoked and with no plan to promulgate new ones. So we'll see what happens. But I think the goal has been to make it smaller. And I think in the big beautiful bill there was also like the ability to pay a fee to bypass NEPA review. So get ready for lots of fighting. If you are in the 30 states that don't have a state equivalent.
We just had a question following up on the 401 certifications comment or answer.
Yeah,
Is
I
it-
can
yeah,
take
go
that
ahead.
one to elaborate further on what I said before. So it is the role of the state or the tribal government to issue the certification or to waive the right to issue the certification. The Corps, the Army Corps of Engineers, needs to receive that certification or waiver before it can issue a dredge and fill permit. So the Corps is not creating the certification, it's receiving it and then can issue the dredge and fill permit.
And just to clarify, in case there was confusion, most people think of the Clean Water Act and the EPA of why and I think you mentioned this at the very beginning of why the Corps still has basically some legacy elements to them in the Clean Water Act. Do you want to clarify that again real quickly?
Oh, sure. Well, if we go back to the early history of the Clean Water Act and those first cases that I presented from the 1800s, you know, those early cases were concerned with the discharge of refuse into water bodies that could interfere with navigation, or the construction of a bridge or some kind of permitting requirement. All of those were focused on navigation and the ability to navigate the waters, in fact. And so the Corps, under the Rivers and Harbors Act, you know, that had a role starting from 1899 in permitting discharge of refuse into navigable waters. And so that role of the Corps has been, you know, continues to this day into the Clean Water Act.
All right. I figured there would be a data centers question at some point along the line here. So some industries use a great deal of water and produce water that cannot be used for drinking, although there can be some high-level treatment. But data centers are one such industry. Are there any rules that restrict such uses to protect water availability for drinking?
It is state by state. So unfortunately, the way that the Safe Drinking Water Act is formulated, it deals with water once you receive it. It's not as focused on source protection, although theoretically that is in the act itself. So really, we end up leaning on the Clean Water Act to do source protection. All of these data centers are supposed to have permits. Many of them do not, and most of them are releasing not only like problematic sewage, but most of them are releasing hot water. So they're taking in an obscene amount of water, using it to cool the data center and then putting it back, which, as we mentioned before, is a form of pollution. There's some not great case law from the mid 2000s between an energy company and the EPA about hot water pollution in particular and its effect on species. But so long story longer, I think we really have to lean on states. In theory, there is a framework even under the federal system to kind of bring data centers into compliance, but no one is really doing it. And in some states, like Texas, for example, they're promoting the creation of data centers, particularly in areas that have been historically left behind by manufacturing or have had slower economic development as a way of kind of building new jobs. But it's not building a lot of new jobs and it's causing a lot of environmental harm. One of the big issues we have up where I am is that they're running data centers on coal. They're bringing back online coal plants and nuclear energy and all sorts of weird stuff that only funds or only provides energy to the data center. So it's not on the grid. So it's not regulated through the normal kind of channels, and the state has no idea what to do because they're like, they need a Clean Air Act permit, right? And it's like, yes, they need a Clean Water Act permit too. But I think this is a area that is emergent for a lot of regulators, and they're having a really hard time kind of catching up and trying to figure out what they have authority to do. So I would, yeah, so there's a comment that they're also hiding the level of water use by not being direct dischargers. That's also true. So I think there's a lot of loopholes to close and science to come. I do know that the National Academies of Science, Engineering, and Medicine is likely doing a program on data centers in the next like 9 months. So I think there's going to be additional science also on how to deal with data centers and their effects on water supplies in particular.
Well, Adam, is there anything else you think we should cover? I was just looking over the chat and the Q&A, and I think we've gotten to
Great.
everything, but we still have some time available.
There's a question in here about the Maui decision and the definition of point source. Would
Okay.
either of you like to tackle that?
Robin, is it nose goes?
Yeah, I can take it.
Okay.
I'll start off with
I was
it.
like, I could talk about, I'm more familiar with the commingled waters aspect of it.
Okay.
So
Okay.
if you could take the point source part, that would be awesome.
Yes, absolutely. So the County of Maui case concerned a wastewater treatment plant in Hawaii. And what this plant did was treated wastewater, and then instead of directly discharging that treated effluent into a surface water, it discharged it underground. However, Hawaii being an island, this is very close to the coastline. And so that just this water that was discharged into the subsurface then quickly came out over a cliff and became commingled with the ocean water. So the question in that case was, everything we've talked about has been focused on permits of discharges to surface waters, right? Not to groundwaters. Because discharges to groundwaters are not considered a point source until Maui. When the Supreme Court held that this system that like discharged to the groundwater that then came out to the ocean was effectively a point source discharge, and that this was just another way of conveying water, just like we could have had piped it out to the ocean directly. And so this was to be included in the scope of the Clean Water Act, and that an NPDES permit was needed for this discharge. That opens a so much broader question, which is sort of what is the functional equivalent of a point source? I would also say that, if we had a more direct way to control underground injection, like if there wasn't a huge loophole in the Safe Drinking Water Act about that, or if we had better ways to control non-point source pollution, we wouldn't have to go through these like legal gymnastics to be like, okay, well, it's not a point source, but it's the functional equivalent of a point source, so we're going to treat it like it's a point source. We're going to treat it like it's a point source because that's really the only effective regulatory approach we have. This concept of like the functional equivalent of a point source is something that we could see expand over time. So this was just one case study, but there might be, here's an example, is like the tile drain case that I presented from Iowa. There's that exception from the Clean Water Act, or saying that agricultural runoff is not a point source. But here we have the tile drains collecting the water and conveying it in what looks a whole heck of a lot like a point source. And we haven't had a decision on the merits of that question.
Anything you want to add, Camille?
I just think it's helpful to know that there are states that have also adopted this framework before County of Maui happened. So really it kind of comes down to how interconnected the water is between the groundwater and the surface water system. A hydrologist would tell you they're all interconnected waters. But when County of Maui is a little unique because Maui has a really old sewage system and also is very close to the beach. And so some of it has to do with the unique geography of like how far from the ocean can you get, and you can't get very far. One of the things they're doing actually with the Maui rebuild after the Lahaina fire is redoing their sewage system so that they don't violate County of Maui, which they wouldn't have been able to fund actually had the fire not happened. So there's a lot of places where this is happening. It's really interesting. I mean, the ultimate goal is to protect human health and the environment. And that was what the case was ultimately about. It was that, you know, you have higher levels of nitrates coming out of this water and it affects the coral reefs and creates algal blooms and all sorts of other things that can affect use of the water. So there's often like good policy reasons for people bringing these cases, and we just have to figure out the in between. In California, the like signature case about whether or not you could, it was about whether you could draw groundwater. So it wasn't about discharges, but about use. And essentially what they found is when you have shallow wells that are connected to the surface water and it's lowering the river and the ability of the river to provide fish. In this case, there was a tribal reserved right to fishing. So the fish have to be preserved at a certain level because those rights are older than any of the other rights in the area, and are backed by treaty. And so in California, the court said when you're that interconnected that you have a shallow well, essentially that's drawing directly out of the river through an underground stream, you can be regulated even though you're a groundwater system. And that's kind of what County of Maui is doing, but on the discharge side.
Great. I don't know whether there any 319 money has ever been used for promoting certain fertilizers, low phosphorus fertilizers, et cetera. But the question is, are there known grant programs that support safer fertilizers for Iowa farms? Anybody know?
I don't know. The grant programs that I am aware of are ones that are focused more on either riparian buffers, cover cropping, erosion reduction measures. That's not to say that there isn't any regarding fertilizer. I do believe though that like there was a particular product that was mentioned. It's hard to envision that there would be a grant program that favored any one product over another product. So I'm not gonna say no, but I'm gonna say I've never seen one.
I've only seen them on the private side, so I haven't seen federal grants. I think there was like a public-private partnership in Iowa that was like linked with USDA under the Biden administration to help folks get guidance on it. But I haven't seen a lot of other grants, unfortunately. I do know, I think it's Ohio. I could be wrong. Maybe it's Missouri, and Robin can tell me that I've got my states mixed up. But I think it was Ohio had like a farmer-led program where you would do like certification in kind of how to do fertilizer application. And if you went through the program, you qualified for certain insurance, and like there was like a tax on fertilizers, and there was a bunch of stuff to basically bring down the amount of nitrate use because there's a high degree of nitrate in the water already. So you don't actually need as much fertilizer. And so there was cost savings. So I've seen kind of innovative programs like that, but I haven't seen full scale widespread, you know, funded projects to substitute fertilizer. You know, if you talk to folks out from where I grew up, they would say you should be doing better agroecology, but that is not how we have set up agriculture in the Plains states. So hopefully there'll be more made available for Iowa. I know that there were a lot of there's some great comments in the Q or in the comment section or the chat on this, and there might be some folks from Iowa who know better, but my impression is that like civil society and foundations are really kind of taking the laboring oar on this, and so are farmers. And so and the programs seem to be administered sometimes through state departments of ag, but it seems like a lot of it's just happening directly from the private sector.
And since you brought up that program, I'll just quickly flag that on the road salt side of things too, there's some similar really cool programs in some different states. The next question was, what is the relationship between TMDLs and 319 plans? I'll quickly say that there can be some prioritization for 319 plans in waters that have TMDLs, but these tend to be fairly distinct programs and plans. The 319 plans are usually referred to as 9-element watershed based plans. But there is a lot of effort among the states right now to merge these, produce documents that meet the criteria for both a TMDL and a 9-element plan. So trying to create some efficiencies where there is a fair amount of overlap in practice between those two documents. Yes, the Yakima River adjudication, I agree. Can you talk some more about the water treatment plants and their burden in terms of taking in water quality challenges?
Sure. I mean, it's that they have them, right? Robin, I don't know. Like, so for example, and Robin, please chime in because you know this much better than I do. But so nitrates are one of the most expensive, difficult energy and water wasting types of issues to treat. And so I'm thinking water treatment for drinking water, but also there's water treatment for sewage. And you have to treat for both usually, and there's different standards depending on what the intended use is. But certainly when you're treating nitrate water for drinking water purposes, it's incredibly expensive. You have to use reverse osmosis, and there are not a lot of approved technologies that the EPA has greenlit on how to do it to standard. So essentially what ends up happening when you have like pollution from upstream is that the downstream folks pay for it, even though the downstream folks didn't create the pollution, and it creates a lot of political tension. And that's what we're seeing in Des Moines, for example, right? Like the folks in Des Moines did not put nitrates in the water. They may benefit from the agriculture in the state, but they're probably also not consuming a lot of the agriculture of the state because Iowa is a net exporter of its products. And that tends to be the case in a lot of the agricultural states. So you've essentially transferred the cost from the polluters down to the water users. And this is like one of the big economic fairness questions in pollution regulation in general. In theory, if we had a stronger clean water, if we paid more attention to source protection, so if we were protecting the Des Moines River, then it would be cheaper and more affordable for folks on the other side. So that's what I'm thinking about when I'm thinking about treatment. The other thing that's difficult with treatment is what do you do with the solid waste sludge afterwards? So that is like a perennial issue if you're talking about sewage treatment. And it's also, I think, why you end up with so many older systems that basically just pumped raw sewage out into waterways. And then we decided that we could not live that way, which is accurate from a public health standpoint. But I don't know, Robin, what do you think?
Yeah, that was great. The only thought I would add is, the Iowa case is really focused on, I mean, yes, it's a water of the US, but it's an intra-state issue from a city in Iowa suing irrigation districts in Iowa. But this concept of the upstream nitrate pollution causing harms downstream, that's the Gulf hypoxia that contributes to the Gulf hypoxia. So we see this issue at the interstate and the international level.
Yeah, and certainly on the Missouri and Ohio rivers, like on both the tributaries to the Mississippi, all three of those rivers are dealing with massive nitrate issues, and it's all from agricultural from multiple states, like Robin said. So even though we're seeing it acutely in some places, it's also showing up acutely downstream.
We're probably only going to be able to get to two last things. One of them is someone asked if they could have your contact information, if it's possible to throw your email address in the chat. While since this is summer school, I want to make sure that we get to this question that is more on careers and looking forward. So Chad Fulmer wrote that I currently work as a project operations manager doing PFAS remediation on remote sites across Alaska. My goal is to start law school in the fall of 2026. I plan to focus on legal practice on PFAS and other emerging contaminants, but the more I learn, the more I'm torn between focusing too much and keeping my options open. What would you recommend? Is there a certain aspect of environmental law that is saturated with attorneys already? What are the majority of opportunities to influence laws, change policies, regulations, and protect the environment?
I have some thoughts on that. Which is that this person comes with very specialized background. I think that going into law school, like a regret that I had was that I took too much environmental law. I wish I had taken bankruptcy. I wish I had taken secure transactions. I wish that I had taken some other courses that are are adjacent to the practice of environmental law. And so when I'm advising students, I recommend a broad base. A lot of the details of the, whatever, if you want to do section 401 of the Clean Water Act, that could be your whole career, but that can come later. That can come in your work experience. When you're a student, get as broad a foundation as possible.
It's a good question. So when I went to law school, I had only one goal, and it was to be an environmental justice attorney, which I was reminded has been outlawed by the federal government, but here I am. So, so that was my goal. And so I thought that I would probably study environmental law. I actually ended up becoming primarily a local government law and transactional law attorney. So I did a lot of community development law because when it came to being able to get access to these revolving funds, that's where I did a lot of my practice. It was on helping very low income communities who could not afford a lawyer get access to money so that they could address these persistent drinking water and sewage issues that they had. If you had told me that that's what I was going to do when I started law school, I would have been very surprised. I thought I was going to like just litigate the entire time. I would say that there is a lot of room for environmental attorneys right now. We need them still. And that the practice of environmental law includes, attorneys who represent polluting industries, but that also means advising them on how to be less polluting or how to be more sustainable. And there's room for people everywhere. My understanding is something like 20% of environmental work is regulatory and policy related. About 30%, 30 to 40% is litigation. The remaining is transactional, which is what Robin was describing when she's talking about securities. You'd be amazed how much securities law is involved in like solar credits, for example, or these data centers transferring like synthetic credits across state lines in the energy sector. I certainly run into a lot of issues. One of my mentors was a bankruptcy attorney for the state Division of Environmental Enforcement, because one of the major things folks do when they get sued is they declare bankruptcy because they've got all these shell corporations. So depending on what you're interested in doing, I would say keep your windows and doors open, explore it all, and be willing to go where you want to go. And if you have a really clear sense of what you want to do, that's okay too.
And I throw out there, check out the internet. Find out what kind of jobs are out there, what kind of roles, organizations, etc. Cold email people. Just see if you can get a conversation going to learn more about what's out there, what you might be interested in. And I would also, in addition to the academic experience through law school, take advantage of your summers, take advantage of externship opportunities and so forth. There's so many different ways to get a sense of, do I like litigation or not? Do I want to go into policy? Is this a subject that I'm particularly interested in or not? Don't shy away from something if it's really your passion. But as Professor Robin and Panu mentioned, like keeping your options open, you never know what other things you're going to find. So I don't want to go, we've hit the top of the hour. I want to say a big thank you again to Professors Panu and Rotman for all the information and the answering the questions and so forth. Greatly appreciated. And Madison, is there anything you'd like to cover before we go?
I also want to give a huge thank you to our wonderful speakers today. Thank you to Adam for moderating and to Professor Rotman and for your comprehensive presentations. We so appreciate your time, energy, as well as your willingness to answer so many audience questions. Thank you as well to our audience for tuning in. As we said at the beginning of the webinar, this program was recorded and the recording will be posted to ELI's website and YouTube page within a few business days. We'll see you next week, either online or in person at ELI's office in DC for our environmental justice session. The week after that, we will be back online for our hazardous waste insights session. You can find out more information about summer school, including the registration links for all upcoming sessions at eli.org. We've also dropped that link into the chat. And lastly, programs are made possible with the support of ELI members. ELI membership is free for students. Members can attend exclusive member webinars. They also have access to our entire webinar archive, along with many other benefits. If you are not already a member, we encourage you to visit eli.org to join. Thank you all so much and have a wonderful day.